A permanent injunction is hereby issued prohibiting the first, third, fourth, fifth, and sixth respondents, jointly and severally, whether acting by themselves or anyone under them, from operating or deploying rangers or guards to operate in any part of Chari and Cherab Ward, Merti Sub-County. 5. An order is hereby issued directing the second respondent to coordinate with the eighth respondent and the petitioners and offer necessary facilitation on the registration of the community land in Chari and Cherab Ward, Merti Sub-County under the Community Land Act. Before moving to court, out of those efforts, the National Land Commission gave an advisory dated 14th of June 2021, noting that the first respondent had been suspended until the community was sensitized and approved the first to sixth respondents' initiatives. Equally, the ninth respondent, by a letter dated 31st of May 2021, acknowledged receipt of the complaints by a section of Merti residents of non-inclusion in the community engagement of the proposed conservancy. In a letter dated 9th of May 2021, the ninth respondent directed the first respondent to hold the establishment of the conservancy until there was inclusive, participatory, and wide consultations with the local community. All these attempts were ignored by the first respondent. Equally, the second, seventh, eighth, and ninth respondents before this court did not say whether they enforced the resolutions alluded to in Annexures A03, 4, 5, and 6. In view of the foregoing, this court must therefore issue orders that not only remedy the violations but also reinforce constitutional accountability and discourage any future disregard of participatory and lawful processes. We now summarize our findings and conclusions on the issues framed for determination as follows. 1. It's our finding that the petitioners have the requisite local standard to institute this petition on their behalf and on behalf of members of Merti Sub-County, Chari and Cherab wards in Isiolo County. 2. We find that the petition before the court was pleaded with sufficient precision, setting out the nature of petitioners' alleged violations and meets the constitutional threshold set out in the Anarita Karimi case. 3. We find that the petitioners did not, in instituting this petition, breach the doctrine of remedies. 4. We find that the petition raised justiciable issues, controversies, and significant questions of fact and law, whose resolution lies within the ambit of the Constitution rather than statutes. 5. We find that the second and eighth respondents have breached their constitutional and statutory mandates by facilitating, or rather by failing to facilitate, the registration of the unregistered community land in Chari and Cherab wards, Merti Sub-County in Isiolo. 6. It's our finding that the establishment of the conservancies in the unregistered community land in Chari and Cherab wards has been undertaken in breach of the constitutional principles of public participation as enshrined in Articles 10 and 69, 1, D, E, and F of the Constitution. 7. We find that the first, third, fourth, fifth, and sixth respondents are conducting activities relating to community conservancies outside the constitutional and legal frameworks and have, as a result, infringed and violated the petitioner's constitutional rights, including but not limited to property rights. 8. We find that the existence and operation of armed rangers in the conservancies in Chari and Cherab wards under the management of the first respondent are illegal and unconstitutional. Ultimately, the court finds that the petition is merited and proceeds to issue the following orders. 1. A declaration does hereby issue that the establishment of conservancies in Chari and Cherab wards, Merti sub-county, was undertaken without due public participation and is consequently unconstitutional. 2. A declaration does hereby issue that Cherab Community Conservancy, operated and chaired by the third respondent, and Bulesa Biliko Community Conservancy, operated by the fourth, fifth, and sixth respondents, are operating illegally insofar as establishing and purporting to establish conservancies in Chara and Cherab wards, Merti sub-county goes. 3. A permanent injunction does hereby issue prohibiting and forbidding the respondents, jointly and severally, whether acting by themselves, their agents, servants, representatives, assignees, and or umbrella bodies of the first respondent, from entering, mapping, surveying, and delineating, carrying out conservatory operations, including the recruitment, employment, or entering into any other forms of contracts, evicting community members, carrying out any activities, or in any way disposing the unregistered community land in Chari and Cherab wards, Merti sub-county. 4. A permanent injunction is hereby issued prohibiting the first, third, fourth, fifth, and sixth respondents, jointly and severally, whether acting by themselves or anyone under them, from operating or deploying rangers or guards to operate in any part of Chari and Cherab ward, Merti sub-county. 5. An order is hereby issued directing the second respondent to coordinate with the eighth respondent and the petitioners and offer necessary facilitation on the registration of the community land in Chari and Cherab ward, Merti sub-county, under the Community Land Act. 6. An order does hereby issue directing the seventh respondent to revoke any and all licenses and authorities that may have been granted to the first, third, fourth, fifth, and sixth respondents related to the establishment and management of community conservancies within Cherab and Chari wards, Merti sub-county. 7. An order does hereby issue compelling the ninth respondent and the Isiolo County Police Commandant to oversee the implementation of the orders sought herein and to ensure that peace and order is maintained. 8. The court declines to grant any damages. 9. Costs are awarded to the petitioners to be borne by the respondents jointly and severally. This judgment is dated this 24th day of January 2025.